Seeing no one, I'll come back to the committee for further discussion and action. Representative Perry?
Thank you, Mr. Chairman. I make a motion that we pass on HB 375 as amended with a favorable recommendation.
Representative Farrar?
I appreciate the opportunity to be here. People ask me why I get involved sometime with these parent time relocations and parent time, and I need to disclose that I actually have a son that's a non-custodial parent, and I understand very clearly when he has the opportunity to be with my granddaughter, his daughter, how important that time is, and the needs of these non-custodial parents and the needs of the children to be with the non-custodial parent. So I just have to appreciate your positive vote. Thank you.
All right, thank you. I see no other lights. I'll call the question on the motion. You wish to sum?
I'll wait.
All in favor say aye.
Aye.
Opposed? Motion carries unanimously. Representative Perry?
If the committee would be okay, I'd like to make a motion that we put this on the consent calendar.
Anyone have any reservation about that? I see none.
I would appreciate being on the consent list laid out. Thank you. And for this bill, I think that would generate good support from the floor. So I appreciate that motion.
Thank you. All in favor say aye.
Aye.
Opposed? Motion carries unanimously.
Thank you, Mr. Chair, members of the committee.
Thank you. I'll move first substitute House Bill 348, child support amendments.
We wanted to make sure it was clear that there's judicial discretion in this matter, and the amendment clearly states that.
We have a quorum. All in favor of allowing amendment number 2, the first substitute House Bill 348, please say aye. Aye. Opposed? Motion carries. You may proceed.
Thank you, Mr. Chair. Currently, as we are aware, Utah law presumes that a parent who stayed at home to care for the children during the marriage can earn a certain amount of money, which is referred to as imputed income, in the event of a divorce. We don't have a provision in our current code to address those issues under certain circumstances, and what this piece of legislation does is allows the court and the parties involved to consider that. I recognize, representatives, that this is a very emotionally charged issue. There's a lot of emotion that goes around the arrangements and that circumstances and how parties are going to move forward in caring for children and for one another as a result of a dissolving of the marriage in a family. What we're trying to do with this piece of legislation is create the opportunity in specific circumstances for the parties who desire to agree to not impute income and still be able to use the online court assistance program and to preserve the parents' arrangements for child support during the marriage.
Thank you, Mr. Chair. Good morning, Representative Stan Asmussen, representing Sutherland Institute. I'm here with a statement on this proposed legislation prepared by Mr. William Duncan, who is the director of the Sutherland Center for Family and Society. He was not able to be with us personally this morning. HB 348 will allow courts to honor the agreements of divorcing parties who are willing to allow for a greater child support order when one parent was primarily caring for the children at home during the marriage and is thus unable to get back into the workforce quickly. It would also allow the court to take that circumstance into consideration when determining a support obligation. Current law requires the court to assume, to impute, that the parent who had been devoted primarily to the children's care can earn a certain amount of money without taking into consideration that the agreement of the spouses to have one parent at home with the children will cause the primary care spouse to forego work and educational opportunities that are not immediately available just because of a divorce. Importantly, the bill does not punish the person obligated to pay support when not at fault, since it allows for imputation when the parent at home was at fault for the divorce? Thank you.
Danny Hartfixon, and I wanted to also address your question about the recent work history. That is already a part of this section of the statute and something that the court already looks at for other purposes in imputing income. So it's something that they deal with regularly. And some of the other points I wanted to make on this bill is one of the biggest problems that we have in Utah is poverty. And in the most recent statistics that we have are from 2011, so that would be the current, what we have access to. In 2010, 37.1% of women head of households with children were in poverty. And in 2011, that went up to 40.1%. And the next part is that on average, families need an income of roughly twice the official poverty level to meet their basic needs, including housing, food, transportation, health care, and child care. So when we're talking about poverty levels, and knowing that that poverty level is 40% with women heading these households, this is primarily who ends up being, they were originally a stay-at-home parent. These are the parents that end up, not, when they're imputed income, not actually being able to make this income often and ending up in poverty, and it hurts the children. The next point is we were heard briefly in the Health and Human Services Committee before we got sent back here, which of course is the best place to be. But there's an argument that this will cause more acrimony in divorces, and as we know, and Representative Hutchings made clear last year on another one of our bills, divorce is already so acrimonious. This is not going to increase acrimony in divorces. And the other part is we have a major problem with imputed income anyway, and yet we haven't found something to replace it for. It's applied in many situations for equitable purposes, so we need it in the statute, and yet it's applied unfairly in cases like this. And so we want to encourage parents to provide for their children, and yet we don't want to artificially remove that obligation from one parent in order for that obligation to be transferred to the state. We would want those obligations to be met by the parents before that ever happens, and that's what happens when income is imputed in these cases. That's what happens, is that obligation gets transferred.
Thank you. I'm looking at line 82 and trying to determine what a stay-at-home parent is. I guess that was me. Certainly with what I make up here, I was spending time at home with my children, but wasn't there a lot during certain parts of the year. So I'm not sure exactly what a stay-at-home parent really is. I mean, was it a few months I took off after my son was born, my daughter was born, and then I went back to the legislature? I don't know what that is.
The idea is to also allow equity to look at what was actually done during the marriage. A lot of these times, these are agreements that are never recognized by the courts because they're not in writing and they're hard to determine other than what was actually done during the marriage. And this will allow the courts to look at that with equity. And so if you have, as you said, if you're a stay-at-home parent primarily caring for the children, but yet you have income, they already consider your actual income. We're just trying to allow the courts to not actually make artificial income that was never there in the first place.
Check the box, no fault. Did anything bad here? I mean, I really wonder about it. All it takes is the other, just kind of curious about that.
Would you like to respond?
Sure. And we were referring to fault in the OCAP program, is that right?
Mm-hmm.
Okay, and I'll answer the other one too after I do this one. So yeah, the situation was there were two parents who did a mediation. They filled out their papers and they submitted them to the court, and they got a letter back from the court that said, you're not allowed to do this, you have to impute income. So so as you look at fault there, the language we have is just that there has not been a determination. So if they actually decide to go to court or an administrative proceeding and there's a determination, of course we know that doesn't happen in administrative proceedings, so they can go forward and move on with this. So that's how that addresses with the OCAP program. As far as the other part, the thing that we all know about imputed income is it's used for child support, to calculate child support, but it's also used to calculate alimony. And in child support, it actually doesn't make a huge difference if you go through and, do samples of where child support's imputed, where income is imputed, and examples where it's not. It doesn't make a huge difference. However, if we're looking at differences of $40 and $50 a month, that makes a difference to the stay-at-home parent who cannot actually go out or cannot or chooses not to go out and obtain full-time employment. Second of all, by allowing fault to be considered, going back to the alimony statute, it allows the court to use its discretion.
Yes, I was waiting because I wanted to speak in support of the bill at the appropriate time, but I want to address the question about the scenario that I think we're wandering a bit here unnecessarily. What I've witnessed over about 30 years, and I've seen it too often, and this bill will correct it. Here's the scenario, one of many, but here's one, that all by itself justifies the bill. A woman gets an education sooner than her future husband. She works to put him through school, including graduate school, including law school. He becomes an attorney. He makes a lot of money. They have children. Even though she had an education, the early years of their marriage, she becomes a dedicated, faithful, stay-at-home mom all that time. And then with the money that the husband now gets, he wanders and he's unfaithful. And that destroys the marriage and it causes a divorce. And then when he tries to make it as cheap as possible, he says, you have an education, you're qualified. You should have imputed income. It should shrink my financial responsibility for my conduct. And so then under the statute, you would have imputed income to someone who faithfully, and by default, we passed legislation last year addressing the fact, as the court asked us, that there are settings in which fault is relevant for spousal support. But now for imputed income, someone can unjustly advantage themselves and make a divorce even worse than it would have been. As far as that little extraneous point on the software, line 60 in the current law, income may not be imputed to a parent unless the parent stipulates. You're supposed to have a proceeding and a hearing. If that's not the case, I think the court system needs to go read that line and work it out internally on their own. And so I would support the bill, thank the bill sponsor, and hope that helps elaborate a little bit on the scenario you might be looking for.
State your name and who you represent.
Good morning, I'm Rebecca Halliday. I am a stay-at-home mother. In 2007, I lived a domestic abuse situation with 2 small children, ages 1 and 4. I divorced in the state of Utah. Income was imputed to me and child support was calculated according to the law. I had been staying at home with the children during the marriage for the best interest of my children as I supported my husband as he became an airline pilot. As a stay-at-home mother, I got my children up in the morning, fed them breakfast, directed them, nurtured them, taught them, drove them to school and activities, ensured that they were not left alone and that they were cared for. After the divorce, my ex-husband upheld child support funds and alimony. He left the state and the country and gained financially. In 2008, since 2008, I have carried the majority of the financial, emotional, mental, spiritual, and physical burden of raising 2 children. With the help of ORS, at times I have been able to get the child support ordered, but even then it was not enough. Child care costs were often difficult to manage. There have been times when I could not pay my bills, and I have been acted upon by creditors. I feel that my ex-husband should help to support his children since he is able to. There is ample evidence that he lives and has lived and continues to live an extravagant lifestyle while we struggle. At times, I struggle to keep even a roof over our heads. the legal burden of attorney fees is too great to try to get more support through the courts from him. There has to be an easier way for children to be fairly supported by their other parent, and the parent who is not the primary care provider. I ask that you support this bill.
Hi, my name is Michelle Jones, and I'm a licensed clinical social worker in private practice, practicing for 15 years. I divorced and was a single mom in 1995, and at the time had 4 children. And I'm opposing this bill for a few reasons. Well, personally, I didn't get child support on a regular basis, but I knew that was a problem in the marriage, and so I felt 100% responsible to take care of my family. And I said I need to get the skills to support them so that I'm not dependent on an undependable person. And it benefited my children greatly to see me go to school, get a degree, and set the example. My concern, an example that you can pull yourself up out of hard times. My concern with this bill is that although it may benefit some people, it opens up to something I've seen over and over and over through my years in family therapy, is manipulative people who can, it creates an opportunity for more disparity. And so I think that leaving it as it is, it still will address these situations if presented correctly in court. But I don't want to make the situation worse because, as most of you know, or if you've been through divorce, people don't play fair. And if we open up an opportunity for a loophole, it may take away the incentive to develop our skills and to pull ourselves up. And so that's just another factor to consider, is that I don't think that it's healthy to look at people are victimized, they go through hard times, but I don't think it's healthy to do anything that would reinforce that identity.
Mr. Chairman, members of the committee, my name is Dan Duell. I represent the National Parents Organization of Utah. We rise in strong opposition to this bill. First of all, I want to thank the good representative next to me. He did give us a seat at the table as we were in discussions of this, and he was very kind to work with us on this. We do have sympathy for what he's trying to do and what he wants to do, and including one of the previous people that testified, because raising children, especially multiple children, is difficult, and holding down a job when a parent has been out of the workforce for a period of time is certainly not easy. And the more children, including the younger they are, the more challenging it will be to find a job, sustain it, and still care for the kids. After all, what point is it to go get a job if minimum wage is all going to go to a daycare provider? This issue typically comes up with parents in their 30s and 40s, whereby one parent is the breadwinner and both parents have decided that the other parent will stay at home for the children. At the time the decision was made, both parents probably thought it was the children's best interest. But as divorce happens, we frequently see a bit of revisionist history that tends to go on in some of these discussions when a divorce happens. What we must understand is that the court does currently take into consideration all of these factors that have been discussed today when determining income or income's ability if a parent is not working. Some of those factors might include work history, education, marketable skills, and others. When determining income ability, it is also important to note that the court does look at the Bureau of Labor Statistics. They don't just pull these numbers out of thin air, and this is not looked at in a vacuum. So the idea behind our opposition to this is that both parents are have financial responsibility for their children, and that it is important for a parent, if they have the education and ability to work, that they ought to go to work and take care of their children and do their part financially.
I don't think we can get this bill worked out now. I'm not comfortable with it. If the sponsor wants to spend some more time on it, at this point, there's no way I can support this bill even with the amendment.
Okay. Any discussion in substitute motion? Representative Christian, do you have a question in substitute motion?
Yes, I oppose the substitute motion and would respectfully oppose the motion to amend. I look at it, but I think that the language as presented speaks to the focus and the issue, and that would have the effect of not voting on the bill as presented. And if the alternative was just a tweaking of something, I don't think that's grounds at this point to avoid the vote on the bill itself after all the time that we've spent on it. So I would strongly oppose the substitute motion.
All right, seeing no further questions on the motion, I'll place the motion here. All in favor of moving on to the next item on the agenda, say aye.
Aye.
Those opposed, say no.
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 Will the noes raise their hand? We have Representative Green and Representative Christensen are no. Four in favor, so it passes. We're moving on to the next item on the agenda. Senator Wyder.